I'm Sam with NATP, back again with Eric Green. Eric, welcome, and it's good to see you again. How
Good
are
to see
you?
you. I'm great. How are you?
Good. I'm good. Getting ready for the holidays, which seems bizarre that it's already this
I
close.
know.
This whole year has flown by. I'm sure everyone will agree. it's,
Yes.
it's been busy. Yeah. So just to recap for everyone who might be joining us for the first time today, we are talking with Eric Green. Eric Green is an IRS representation specialist expert. Eric, how would you describe yourself?
I'm a tax attorney that
Okay.
spends a lot of time fighting with the government.
Okay, perfect. And so, Eric, you are kind enough to join us today. We're going to be talking about some representation topics. You get a lot of questions in your day-to-day work, and so we are excited to share some of those questions with all of the viewers and your expert answers as well. Do you want to just give us a teeny bit of background on you?
Okay. So I and a law partner, Jeff Sklarz, founded Green and Sklarz about 8.5 years ago. Today, we're 23 people in 3 offices in 2 states. And I founded Tax Rep Network, which is where we train tax pros to really build a representation practice.
Perfect. So we will just jump right in.
Okay.
Our first question. So back up a little bit for everyone who is joining us for the first time. We put out a call for questions. Anyone can submit their IRS representation question. Sorry about my dog. Working from home, right? So
Yep.
these are some of the questions that we have gathered and that seem to be popping up quite a bit. So the first question we have is from Beth. Beth's question: we filed amended 2019 return with a refund applied to 2020. The IRS has not processed the 2019 and is now looking for the balance on 2020 with penalties and interest. What should we do because the IRS says they can't tell us when the 2019 will be processed? I think this is common.
Oh, yeah. We're getting a lot of this.
Yeah.
And so there are a couple things. One is you could call collections, request a hold, because what we're waiting for is 19 to get processed. Once that gets processed, 2020, it'll be credited to 2020 and the penalty and interest will go away and everyone's happy. The problem is the government is doing so much with automated enforcement. There's a risk in doing nothing and waiting, just trying to wait this out. What we've actually been doing is filing doubt as to liability offers. So what you do is it's a form 656L. You do a doubt as to liability offer, and I would explain there's an overpayment that the IRS has simply missed. We don't really owe you money, and send in the amended 19, the return for 2020 showing that the overpayment should have been applied. Now the thing is, to do a doubt liability offer, it's an offer. You have to offer something and offer $1. If you truly don't think you owe anything, offer $1. And here's where I'm going with this. That goes in, it will stop collection on 2020. By the time that gets worked, 6 months to a year, 19 will have been processed. The overpayment will be applied. 2020 will go away. And what normally happens in that case, you'll get a phone call from someone saying they have the doubt as to liability offer. They can see that everything has been worked out. Can you just fax them withdrawing your offer? And that way you just get rid of it. But I really don't like gumming up the works at the IRS, but because we're in sort of desperate times with they're unable to process mail, that is certainly one way you can make sure it gets stopped and reviewed.
Yeah, and a follow-up question on that, just from your own knowledge of the IRS and the inner workings, is there any hope in sight for them to be caught up anytime soon on things? Are we expecting still long delays? Do you have any insight on that?
They are supposed to be hiring another 400 people who will just deal with processing the paper. How much paper those 400 people can process and what kind of a dent that makes, I don't know. I think we're going to be in this situation for a while.
Okay. So it's going to be important then for people to know how to do these types of offers.
Oh yeah, well, I have to tell you, I think the need for representation has never been bigger. One, from just on sheer numbers. Before COVID, we had 25 million people in trouble, 15 million in collection, and 10 million non-filers. COVID has driven that up. The IRS estimates as much as double. So you could have as many as 40 to 50 million taxpayers in trouble. And more is being done through automation. So the need to have a trained representative that knows what they're doing, understands this, has never been higher. The opportunity to build your practice and add this service to your practice has never been bigger, which is why we were so excited about the partnership with the NATP, because there's a real need in this area. So for those of you who are out there thinking, I hate tax season, I hate the grind of 1040s, but I'm not going to go and make a career change. You don't have to make a career change. Pivot your practice and focus on those things that you can do that are really value added.
That's a good.
This is one of them.
It's a really good point there. Yes. So let's jump to the second question then, from David. Eric, my client never sent back any documents to the IRS and now has a threat to levy. What number should I call to get it fixed?
Okay, so the client didn't send back paperwork. I'm assuming, Dave didn't say, but I'm assuming that this is an automated under reporter where they propose changes, you submit documents. Here, the client didn't even send them back, but I got news for you. Even if he had, see question number 1, chances are no one would have done anything with them. So the problem is he has a threat to levy. That means a billing notice came out. That means the notice of deficiency came out, so it's gone final. And a billing notice came out. Now we have the threat to levy. Honestly, it's kind of the same thing. I think what you do is there's no number to call to fix it, because if you call the IRS and actually get to a human being, well, first of all, congratulations. But you get to a human being, what they're going to tell you is it's been assessed, it's final, it wasn't challenged in tax court. Oh, well. You're going to do a doubt as to liability offer. And here, what you're going to do is you'll do the doubt as to liability offer, attach the same paperwork that was submitted and explain, we don't really owe this. We had submitted this paperwork. It appears no one looked at it, or my client, needed more time and it went final. Now, the thing is, I just want to warn people, because one thing I got, and we got this at TaxCon, actually, somebody had asked a question saying, Eric, the appeals officer asked me for backup. We had already given the auditor. Don't you think this is an abuse? No, it isn't. And here's why. The IRS, like Sam, you and I, you can see I'm working from home. This is not what my office looks like, my home office. The IRS is working remotely as well. All right. So here's what I would suggest to people. Before you get bent out of shape that you have to send more paper, or the government should already have it. Yeah, in a perfect world, they would, but they don't. So what do we want? And this is the key. Whenever you're at appeals, or it's an audit, or an offer specialist, or whomever, you want to give them everything they need to agree with you. You want to take that person and lead them so they agree with you and come to the same decision that you're asking for. So the critical thing here, I would send the cover letter explaining, and even if you had sent in the paperwork, send it again. And tab it all, because here's what's going to happen. Eventually it will get routed to this remote appeals officer, let's say, and now everything is in front of them. You've made their life easier. A senior partner put it to me one way: make it easy for them to agree with you. So, and I have this, we dealt with the auditor, we gave it to them, they ignored it. Now I'm going to appeals and I'm going to submit the appeals package. Guess what? I'm giving them all the same stuff. Here's why we win. Here's why we should be allowed this. Here's why this expense is legitimate. And I tab it, make it as dummy proof as possible. And, and I've had clients say, well, we already gave this to them. Doesn't matter. When the appeals officer looks at it, if it's complete and in front of them, we are going to get a better outcome than the hope that they're going to now go start searching for things.
Right.
All right. They're not that motivated. They're overwhelmed. They're government bureaucrats for a reason. At 5 o'clock, they're done. they all
Mhm.
work different shifts, but at the
Yep.
end of their shift, they're done. So don't feel, I got the sun coming up. Don't
Yeah.
feel that or it's actually not coming up, it's going down.
Yep.
Don't think that they are going to go out of their way to try to find something to help your client. Same thing here. So what I would do, doubt as to liability offer, submit the documentation, whether it had been submitted or not. Here it wasn't, doesn't matter. Submit it, explain it, make it easy for them to say, oh yeah, they get that. Oh yeah, I see that. Oh yeah, and
Mhm.
get to the right outcome.
That makes sense. Absolutely. Perfect.
I'm gonna slide.
Perfect. Next question that we've got is from Donna. My client has a balance from 2008 that the IRS sent a notice on. In your collections program, you said the IRS has 10 years, so shouldn't this balance be gone by now?
Okay, well, the '08 return, had it been filed timely, would have been filed in April or between April and October of '09.
Mhm.
10 years would be 19. I'm willing to bet that the client either late filed the return or with a balance due may have done things that have told or extended the statute. So what happens is the government has 10 years to collect a tax from the date of assessment. So let's say I would have filed 14, 15, 16 returns today in 2021. And let's assume they were assessed the same day, because now I could mail them in. It could be 5 months before they get opened and assessed. But it's 10 years from the date of assessment. So even though it's a 15 return, it's not assessed till November of 2021. That 10 years will go to November of 2031. So what I would do is I would get a transcript for the '08 year, see when the client filed the return, when it was assessed. All right. And literally you sit and do the math, right? So you figure out 10 years out, and then you look at what else they've done. Did they file an offer that got rejected? Did they take a collection due process hearing? Did they request an installment agreement? The IRS will code it for pending. That will freeze the statute from running. A collection due process hearing, which is an appeals hearing in the collection arena, that tolls the statute. An offer tolls the statute. So they may have done things that have extended it. So I would check that, and that will confirm for you. Now, if you do review that, it was Donna, right? If you do review that and you find that there aren't tolling events, that it really should be expired, you have two options, one of which we've already discussed. You could do a doubt as to liability offer. But the other one, which is usually cheaper and faster, is a 911 with the taxpayer advocate.
Hmm.
Now, I will warn you, the taxpayer advocate is overwhelmed. But I have usually filed the 911 with the transcript and explained that. And I'll give you an example, Sam, because you don't do a lot of this. You have folks who file for an installment agreement, so they penned it for they told it for the pending installment agreement. After reviewing it, let's say a month later, the IRS determines that they're uncollectible. So they'll code them uncollectible, but they never take off the pending code. So that ends up remaining in place. So I've had cases where the IRS, in one of them, we did the 911 saying this expired 8 months ago. Not only did they agree, they had to refund 8 months of monthly payments that the taxpayer that they had been taking from the taxpayer. So the taxpayer got $16,000 back. So you pull the transcript, Donna, take a look and see, from date it was assessed, go out 10 years, then look through, see if there's anything that's told it. If there isn't, or even if there is, if you believe it's gone, a form 911 to your local advocate with all of that, explaining why you think the taxpayer doesn't owe it. They have technical experts they will forward it to, who will review it and come back with either they agree, or if they don't agree, here's why.
Okay, that's really good information. Just a reminder too for everyone who is watching us, if you have any questions, feel free to shoot them in the chat. You can comment on this video. Eric, we will try and answer what we can live here today. So just a reminder before we head into our last question. If anyone watching has anything, or if you're watching this later and you have a follow-up question, we will check that too and answer it next time. But for our last question today, Eric, from Richard, any advice for us when we start getting new cases? I did the blogging and I'm getting phone calls from people who owe taxes. What should I be looking for when I take these clients on? This is a really good starting point, it seems like.
Yeah, I mean, one of the things I recommend to our tax rep members is the idea of blogging. And for those of you who are just listening in or don't know, let me explain why I'm hype on blogging. One is if you blog properly on the right sites, each blog entry is like a mini website. So to me, if you think about the information superhighway, each one of these is like an advertisement. And so what I like about the blogging is a couple things. One, anyway, so anyway, what it is, still going. And anyway, what it is each one of those is like its own little mini website. So when people go searching for you, there's lots of blog entries. In fact, I know because new clients will come in and they'll have copies of my blog. So I know people will go out there and see it. Mm-hmm. The other thing I like about the blogging is you can hyperlink back to your own website. So inside Tax Rep in the marketing area, we actually video me creating a blog. And so I always hyperlink to our landing page. I hyperlink to my bio page and our services page. So now what happens is Google's like, look, we don't know anything about Green and Sklar's, but we know that this, I use Active Rain blog site that we like a lot. Well, it seems to like them. So all of a sudden my bio page, our services page, our landing page, they all start to rank. So it's a good way to create SEO. The last thing is it also forces you to think through it. For those people who are new, it's a great learning tool because you're going to do a blog on the IRS collection process. It forces you to, in 200 to 500 words, we're talking 2 paragraphs, but it does force you to kind of think about what you're writing, and it's a great learning tool. So anyway, back to this. You're now starting to get those clients in. What should you be thinking about? Well, a couple things. One is we get paid up front. We charge for consultations and we take a retainer because this is not like a 1040. Once you file power of attorney, you're in the middle of the case. Don't think that the client being so thrilled with you that they're going to pay you later. They often aren't in a position to do that, even if they wanted to. And to look at it a little bit more negatively, one of my former senior partners told me, Eric, these are people who won't mind screwing the government. If you think they don't mind screwing the government, you think they're going to mind screwing us. So one is you charge for the consult, like, at least in Tax Rep, we teach you to. You get, you take your retainer. There are some new wrinkles to this. The government is using data now better than ever. So we now have a yes, no, the client must answer. Do you have virtual currency? Mm-hmm. Do you have foreign assets? The government, from the FATCA information that's come over and from the John Doe summonses on Coinbase, Kraken, and Circle, they have a huge database of people they know own virtual currency. So what did they do? They ran their database against anyone who'd filed for an offer, anyone who filed to be uncollectible, or anyone who filed bankruptcy where the IRS was listed as a creditor. And the number of criminal cases over from collections to CI went up 42%. So to protect ourselves and protect our client from themselves, and again, in Tax Rep, there's a checklist that you download. We've added to it. Do you own virtual currency? Yes or no. They cannot leave it blank. Do you own any foreign assets? Yes or no. Because later on, if they get caught, they're going to turn around saying, I told you, Eric. Sam, I know I mentioned that. I want to pull out and say, yeah, no, you didn't.
Mm-hmm, mm-hmm. The CYA tactic.
Absolutely. Protect them.
Due diligence.
Yeah. Well, protect you, but also protect them from themselves because, it's in another country. Who'd know?
Absolutely. Yeah, absolutely. Right. It looks like we do have a question from Kevin. Yep. So Kevin asked if a client is on an installment agreement, does the 10-year limit still apply?
So Kevin, what happens is you submit the documents, whether you submit documents, you call and you set up the installment agreement. If you submit the documents and they're being reviewed, the pending agreement will toll or freeze the statute. Once the installment agreement is in place, the statute starts running again. So I've had people say, well, if you're in an agreement, doesn't it keep it like permanently stopped? No, it doesn't. All right. Once the agreement's approved, the collection statute will start running all over again. Or not all over again. It will start running again.
Got it. Cool. I think that's all that we've got today. Unless anyone has any other questions as we wrap up here. Eric, do you have anything else to add? Anything you're excited about?
I think that I would urge people to seriously consider. Well, first of all, what's hot right now? Non-filers. The government is going after non-filers like they're going out of style. People with back tax balances, and here's what we know is coming. So Darren Guillot, who's the SBSE commissioner for IRS, was on the podcast and basically said January 3rd, all bets are off as far as trust fund assessments. These are the folks who didn't pay their payroll taxes. See, up until now, you can defer until January. And so though they have a pretty good idea who's not just deferring, but is actually not paying anything, they're holding off on that. They've already got the green light the morning of January 3rd, Monday, January 3rd. There are going to be millions of business owners getting hammered with the trust fund assessments for those unpaid payroll taxes. So if we are going to get we're already busy, we're going to get busier. So if you're thinking about building a representation practice, no better time than the present. Oh yeah, Chris is looking forward to Vegas. Yeah, we're doing a 2-day workshop, Tax Rep and Tax Help Software. We actually just partnered with the NATP, by the way. We gotta get Roger on one of these.
Yes.
And so we're doing 2 days in Vegas, December 13th and 14th. Yeah, Chris, I'm looking forward to it too.
Yeah, I think that's a good point too. Eric, if people, have any questions or, want to reach out to you, where can they find you?
I'm pretty easy to find, just given all the blabbing I do. But certainly Green and Sklar's is the law firm. My email's on there. Tax Rep Network. You can go and find me there. If you Google me,
you're there. Perfect. Sounds great. That's all that we have today, Eric, unless there's any other last minute things you wanted to add.
Nope, not at all. Thank you all for joining us again, and great questions.
Yeah, yep. And we will see you after the holidays. I hope everyone has a safe and happy Thanksgiving, and we will be back in December. All right.
Sounds great.
Thanks, everyone. Bye-bye.
Bye-bye.